Good morning. We are ready to do your judgments, but I first wish to invite somebody to give me the quorum.
Good morning, my lords.
Good morning.
The observation is as follows.
Yes.
We have my dad friend, Mr. Uhuru.
Wait, is that?
Sorry. What is Mr. Evictees?
The name again? Mr. Mingati is for which party?
Policies concerning people, and I'm also here holding people. My dad friend from the farm of.
We have addressed all the identified issues and now turn to consider the reliefs and orders that we should finally make in disposition of the petition and the cross petition. On the evidence, we are satisfied the petitioners have not proved the petition to the required standard. The petitioners did not prove that any of their constitutional rights were violated as alleged in the petitions. We dismiss both petitions 12 and 13 in their entirety for lack of merit. We are satisfied that the cross petition by the Cabinet Secretary, Ministry of Land and Physical Planning, Cabinet Secretary, Ministry of Interior and Coordination of National Government, County Commissioner, Narok County, and the Attorney General, the cross petitioners, has been proved on a balance of probabilities. Thus, we allow the same and we make the following consequential orders. 1. A declaration is hereby issued that the subdivision of Leio, Enakisomi, Sisian, Enosokoni, and Karoni group branches be owed the initial acreage at the time of adjudication and first registration was irregular, unlawful, null and void, and of no consequence, and did not confer to the respondents any proprietary interest over the land. Those are the respondents to the cross petition. 2. A declaration be and is hereby issued that the subdivided land that was over and above the initial registered acreage of the group ranches land parcels comprised part of Masai Mau Forest Reserve, and the same should be restored to the forest. 3. An order is hereby issued that the land titles created following the subdivisions of Leio, Enakisomi, Sisian, Enesokoni, and Nkaroni group ranches are set out under Prayer B in the cross petition were obtained illegally, unlawfully, and unprocedurally, and hence a nullity ab initio, and constitute unlawful encroachment into the Masai Mau Forest Reserve, and the same titles are hereby ordered, nullified, cancelled, and revoked. 4. The respondents in the cross petition who may still be in the forest land, that is the suit properties, are ordered to vacate with immediate effect and in any event within 90 days from the date of the judgment, failing which an order of eviction shall issue against them. 5. The respondents, cross petitioners, in conjunction with the county government of Narok, are ordered and directed to carry out ground survey with a view of delineating and establishing the Masai Mau forest boundary by fixing beacons and or permanent features, designating the extent of the forest, having specific regard to the initial acreages of the registered adjudicated land to Leio, Enasikomi, Sisian, and Osokoni and Nkaroni group branches within a period of 12 months from the date of this judgment to ensure the forest is protected and conserved for posterity. 6, that once the Masai Mara forest boundary is established as on the 5 above, the respondents, cross petitioners, in order to protect and conserve the forest, shall erect a perimeter fence on the portion of the forest abutting the land adjudicated to Raila and Asikomi, Sisian, and Osokoni and Karon group branches within 24 months from the date of the judgment, and such fence, once erected, shall be maintained by the Kenya Forest Service. That is the 9th respondent herein. On the issue of costs, we are aware that costs are awarded at the discretion of the courts. In public interest litigation cases, the courts are generally slow to award costs against a party, as that could stifle and deter public interest litigation to the prejudice of the public, whose interests and rights may be at risk. In the present petitions, we are satisfied the matter was of public interest, as what was in contest was whether the land allocated to the petitioners was within the Masai Mara forest, which is a critical national resource. We are of the view that it would be punitive to order the petitioners to bear the costs of the petition. We order that each party shall bear their own costs of the petition and the cross petition.
Today is indeed a great day for those who have been fighting for the conservation of the Mau forest. It has been a long journey, and today the court has rendered its judgment well-reasoned and which we welcome. It cannot be overemphasized the importance of this water tower and the critical role it plays in our country as a water tower. The judgment has been delivered today. The illegal titles, which you have always said that there was encroachment into the Masai Mara forest, we have been proved right by the three-judge bench, and we are happy that the court has cancelled and revoked all those titles that were issued over and above the initially declared acreages of the 5 group ranges that border the Mau forest. We are also happy that the public funds have been spared, because the illegal title holders have been flashing and asking for compensation over the titles that were irregularly acquired. And we are happy today that the court has pronounced itself and said that there cannot be compensation for illegally acquired property. And therefore, we are happy. The court has also pronounced itself to the effect that the Mau forest be conserved and secured by erecting a perimeter wall around it. And that responsibility has been bestowed upon government departments, including the Narok County government, to permanently secure this forest for this generation and the generation to come. I want to thank most sincerely those who stood with us, like Honorable Olekenda, who supported us in the fight in the court here. There are so many fronts that have been evoked to conserve the Mau forest. One was the legal department here, and the other one was the executive arm of government. We want to thank all of them who supported us up to this level. Today, we are celebrating. And I can tell you that even the animals, both in the Masai Mau, in the Masai River, and on the land, are happy that this pronouncement has been made. We need to conserve this forest.
Congratulate our lawyers for such a sterling performance such as sterling job for actually assisting the community of Narok to get back what is theirs for their livelihood, for their animals, and also for the other beneficiaries like Egypt, Tanzania, and elsewhere. The most important thing here is that the court looked at the law, looked at the facts, and it reasoned, and the court gave a reasoned judgment. Because the other party has the right to appeal, we will not want to get into the merits of the case, but the most important thing is that the people who have stood firm on the Mau Forests have been vindicated today. More so people like Raila Odinga, people like Uhuru Kenyatta, the former president, people like the elders here, and Mr. Tobiko, who really did a good job. In fact, for the record, it should be known that the forest has already been fenced off substantially. So the most important thing is that the forest, the fence be completed, and any encroachment should be stopped, because what has been happening is that there has been destruction of the fence. So I'd like to thank the court most sincerely as a former leader and as somebody who has been involved in the Mau issues here and in Parliament when I was representing Narok North. I think what has been done today, as Koome had said in the other petition, Raila's petition, that was a decision of God. But I think this one is more so. It's a decision of God, because what has been done today is to restore the Masai Mau, to restore the lives of our people, to restore the Masai Mara ecosystem, and to restore the water for people living and benefiting from the rivers that emanate from the Mau water complex. So I hope the government of William Ruto will continue to conserve and preserve the forest now that they've got a judgment to back it up. It's not
A lot of gaps. It does not appear to have had a good grasp of how eviction has to be carried out. And in their own judgment, the court identified the following: that the people who are given titles were given titles by public officers, the land registrar, and of course through a process of land adjudication. And why will somebody be blamed if the government is the one that gave the titles? Why will somebody be blamed and not the government? Yet it is a very clear principle in law that whatever a government officer does binds the government. That is the principle of vicarious liability. Secondly, there is no eviction in Kenya, and the Supreme Court has ruled as such, which is not to be carried out without being conducted by the National Land Commission. The National Land Commission was sued in this case, in this petition rather, and they did not even file anything, and meaning that there was no participation of the National Land Commission. So we are far from accepting the fact that the eviction was in order. We are also far from accepting the judgment of the court saying that people should be removed. First and foremost, even in their own documents, government documents, you will find out that there were people who are staying, the Okiek whom I'm representing, more than 200 years ago. And they did not need to have a title, they did not need to have the land to be surveyed for them to stay there. So even in the absence of the titles, that still remain part of their land. But because of the conservation efforts, the government should have been able to look for alternative settlement for these people. It's very sad also that the court agreed that indeed there is no fixed boundary for what is called the Mau forests. It's also agreed that the Mau forest is a trust land, meaning that the county government of Narok then could actually subdivide it and give it to the inhabitants. Having noted that, the court should have gone ahead and say the people are living there lawfully, but because of the conservation efforts, the government should find an alternative. It would have been a good judgment if the court were to find that, first and foremost, those who are in occupation in good faith. In other words, there are those who bought land from the initial occupants who did not even have the title because that was their ancestral home. They were there even before the coming in of the colonial settlers or colonial power was established in Kenya. So as we talk now, we are not very satisfied. My clients have instructed me to rush to the Court of Appeal, and we certainly we are not hearing this matter for the last time. We will fight on and on until the coming of Jesus Christ, and we believe that justice will...
Happy that was the direction you took. We are welcoming the judgment and happy that no official stay. Indeed, there is the 90 days stay, but we are glad that this court cannot grant an official stay to actually give Mr. Bosek's clients an opportunity to further go into the forest, because we are sure that that is exactly what they're going to do once given a stay. So they can go ahead and look for such a stay in the Court of Appeal, and we are happy that
no, as now we will just move out of Narok.
Yes, you'll be thanked as official after this.
Wait for you to go to the Court of Appeal.
We will still defend your decision today, the same way that we did to the cross petitions.